is therefore not properly on record. There was need for evidence of the investigating officer by way of an affidavit that the video clips that were played in court during hearing of the submissions by the advocate for the victim were subjected to analysis at the Cybercrime Unit of the Directorate of Criminal Investigations using appropriate tools to confirm that none of those videos was neither interfered with nor was a product of artificial intelligence. Encyclopedia Britannica says the following regarding artificial intelligence, and I quote, "Artificial intelligence, the ability of a digital computer or computer-controlled robot to perform tasks commonly associated with intelligent beings. The term is frequently applied to the project of developing systems endowed with intellectual processes, characteristic of humans such as the ability to reason, discover meaning, generalize, or learn from past experience." End of quote. In my assessment, the video evidence is neither sufficient nor reliable enough to support the submission that the accused person is a flight risk. It would be dangerous to rely on the clip as evidence without a background contextual basis of its existence being laid by way of viva voce evidence and tested. I have gone through the record, and what is clear from the record on the face of the charge sheet is that the accused person, prior to preference of the charge and arraignment of the accused person before the court to take plea, he was out on police cash bail. He was out on cash bail granted by the police, and then he turned up voluntarily to take plea. There is no reason enough for this court to believe that the accused person, if released on bond or bail, is not likely to turn up for his trial. There is no information on record by the investigating officer indicating that the accused person was at any one point summoned to appear before the investigating officer and failed or neglected to do so, and to appear at the time or place as required of him in the summons. One thing that must not be forgotten is that the accused person under Article 50, Sub-Article 2, 1A of the Constitution enjoys presumption of innocence throughout the trial. The same provides that, I quote, "Every accused person has the right to a fair trial, which includes the right, A, to be presumed innocent until the contrary is proved," unquote. Number 2, likelihood of interference with witnesses. The second ground advanced is that the accused person is likely to interfere with witnesses if he is released on bail or bond pending trial. The prosecution submitted that the accused person is likely to interfere with witnesses in this case. The manner in which such an allegation is made should be handled by the court has been explained in two authorities, that is, Panju versus Republic, 1973, East Africa Road Reports at page 282, and Jeffa versus Republic, 1973, East Africa Road Reports at page 39. In the latter mentioned case, it was held as follows, I quote, "Time and again, this court has said that the true test of a bail application is whether the granting of the application will be detrimental to the interest of justice. It is for the prosecution to satisfy the court that this would be so if bail was granted. Dealing with question of tampering with witnesses, Wilson, acting CJ, as he then was, said in Bagwaji, by and Republic, 1, Volume 1 of Times Law Reports, at page 43, quote, "The tests laid down in English cases were that there should be a definite allegation of tampering or attempted tampering with witnesses, supported by proved or admitted facts, showing reasonable cause for the belief that such interference with the course of justice was likely to occur if the accused was released. In this case, there was no more than mere assertion by the prosecution that the applicant would interfere with prosecution witnesses if released on bail. There were also fears that he would abscond. There was no evidence whatsoever to support these hypothetical fears, unquote. And further quote, in Republic versus Anthony Karanja Jeru, 2016 EKLR, the High Court said, quote, it has long been recognized that an accused person who interferes with witnesses does not qualify to be granted bail. In Panju versus Republic, the High Court held that where an allegation of interference with witnesses is used as a ground of opposing release on bail, the prosecution must produce evidence. This was the practice under the Independence Constitution of 1963. The requirement to produce evidence to support an allegation of interference with witnesses is, in principle, good law. The reason being that a decision of a court must be based on evidence. End of quotes. In Republic versus Gerald Mutuku, Nyalika and another, 2015 EKLR, the Honorable Justice E.M. Muridhi J. held that, I quote, in considering the likelihood of interference with witnesses as a compelling reason to refuse bail in terms of Article 49, Sub-Article 1H of the Constitution of Kenya, the prosecution must, in my view, demonstrate a more than whimsical probability of interference. It must be shown that the accused persons are in such close family, filial, or other relationship which create an environment of control and influence of the witnesses by the accused person, such as to interfere with the ability of the witness to give evidence before the court in a free and truthful manner, thereby affecting either the credibility of the witness in his or her testimony before the court, or the very ability of the witness to attend court. The Honorable Justice F.A. Ochieng J. in the case of Republic versus Abel Kiprop Malel, 2014 EKLR, said as follows, I quote, in the case of Panju versus Republic, 1973 EA at 282, specifically at page 284, the learned judge said, quote, as for the allegation of interference with witnesses, I would say that it is not substantiated. It should not have been difficult to do this if such allegation has any basis. The investigator could have sworn an affidavit explaining what he had done and who he had contacted and what the results had been so far. Before anyone can say there would be interference with vital witnesses, at least some facts should be led to the court, otherwise it is asking the court to speculate. Speculation has no limit, and it is for these reasons that I refrain from taking into consideration matters raised by senior state counsel. From these words, it is crystal clear that in that case, the investigating officer did not swear an affidavit. The court was being asked to conclude that there would be interference on the basis of statements made from the bar. End of quotes. What is clear from these authorities is that any allegation of interference or likelihood of interference with witness or witnesses should be supported by a statement on oath by way of an affidavit sworn by the investigating officer. Submission from the bar without supporting evidence on oath does not suffice. mere allegation that an accused person is likely to face more charges per se is not a reason also for denial of bail bond pending trial. And that position too is clear from the decision of the above quoted Banju case. Next is association and influence. The next ground raised as a reason why the accused person should not be granted bail or bond pending trial is that the accused person is associated with influential person and is now, subsequent to alleged commission of the alleged offences, positioning himself in the social media as a brand despite being a fake advocate. I have considered the submissions relating to this point. There is no doubt that as long as freedom of association is enjoyed in a manner that does not interfere with rights and freedoms of another person or others within the confines of the law, it ought not be used as justification for denial of a right, in this case, the right to bail or bond pending trial. An accused person has the right to associate with any person of his choice, including politicians, and it is within discretion of those whom he wishes to associate to decide whether to associate with him or not, guided by their own individual conscience. It would be an absurdity to deny bail to a person on the ground that videos have allegedly been posted on social media depicting the person as an associate of a non-desirable or influential person. Public interest and protection of the accused. It was submitted that the accused person presented himself as an advocate and that it is in the public domain that he alleged to have won 126 cases. Mr. Leori submitted that while the number of cases which the accused person had handled is not known, there is indication from the accused person's allegations in public domain that he has won 126 cases, and therefore there was at least 126 victims of his being an imposter. And on this premise, the prosecution also submitted that the accused person should be remanded in custody pending trial because of his own safety, because there could be at least 126 people looking for him. These two submissions were in support of the contention that it is in the public interest to deny the accused person bail or bond pending trial, and that he should also be denied the same for his own safety. While dealing with the question of public interest, the Honorable Justice Mativo J. had this to say in the case of Republic versus Danstan Kabage Mwangi 2016 EKNR, and I quote, "There is no denying the fact that liberty of an individual is precious and is to be zealously protected by the Constitution and the courts. Nevertheless, such a protection cannot be absolute in every situation. The valuable right of liberty of an accused person and the interest of the society in general has to be balanced. Liberty of a person accused of an offense would depend upon the exigencies of the case. It is possible that in a given situation, the collective interest of the community may outweigh the right of the personal liberty of the individual concerned. Granting bail entails the striking of a balance of proportionality in considering the right of the applicant who is presumed innocent at this point on the one hand, and the public interest on the other. The cornerstone of the justice system is that no one will be punished without the benefit of due process. Incarceration before trial, when the outcome of the case is yet to be determined, cuts against this principle. The need for bail is to ensure that the accused person will appear for trial and not to corrupt the legal process by absconding Anything more is excessive and punitive. The general rule, in my view, is for the courts to try to strike a balance between the need for a tie to the jurisdiction and the right to freedom from unnecessary detention of an accused person before conviction, and the need to bear in mind the circumstances surrounding each case. Thus, in determining bail, public good, as well as the rights of the accused person should be kept in mind. End of quotes. The accused person is alleged to have held himself out as an advocate and proceeded to represent some persons in court proceedings as such. Contention by the prosecution and the victims is that if granted bail or bond, the accused person is likely to continue in his scheme to the detriment of the public and administration of justice. Each case must be treated on the basis of its own peculiar circumstances. In this